We go now to Chapter 7, Notice of Dishonor, Section 89 of Negotiable Instrument Law. Section 89, to whom notice of dishonor must be given, except as herein otherwise provided, when a negotiable has been ordered by an acceptance or non-payment, notice of dishonor must be given to the drawer, to each endorser, and any drawer or endorser to whom such notice not given is discharged. So this is what you call notice. You have to give notice to the issuer, the maker, and or the next to that is the endorser. So any drawer or endorser is not given notice is discharged of payment. Section 90. By whom given? The notice may be given by or in behalf of the holder, or by on behalf of the party to the instrument, who might be compelled to pay it to the holder, whom upon taking it would have a right to reimbursement, on whom the party to whom the notice is given. Okay. Section 91. Notice given by the agent. So, the one who giving the notice is not the principal, but just his agent. Notice of dishonor will be given by an agent either in his own name or in the name of any party entitled to give notice, whether that party to be his principal or not. Section 92. Effect of notice given on behalf of holder. Where notice given by or on behalf of the holder, it inures for the benefit of all subsequent holders and prior parties to whom it is given. Section 93. Effect where the notice is given by a party entitled thereto. Where notice is given by or on behalf of a party entitled to give notice, inures to the benefit of the holder and all parties subsequent to the party to whom notice is given. Section 95. When agent may give notice. Where the instrument has been dishonored in the hands of an agent, he may either himself give notice to the parties liable, or who may give notice to his principal. If he give notice to his principal, he must do so within the same time as if he were the holder, and the principal, upon the receipt of such notice as himself, the same time for giving notice as if the agent had been an independent holder. Very self-explanatory. Section 95. When notice is sufficient, a written notice need not be signed, and insufficient written notice may be supplemented and validated by verbal communication. A misdescription of the instrument does not vitiate the notice unless the party whom the notice given is in fact misled thereby. We're talking about notice sufficient. Section 96. Form of notice. The notice may be in writing or merely oral and be given in terms which sufficiently identify the instrument and indicates that it has been dishonored by non-acceptance or non-payment. It may in all cases be given by delivering it personally or through mail. Section 97. To whom notice may be given. Notice of dishonor may be given either to the party himself or to his agent in that behalf. Section 98. Notice where a party is dead. When any party is dead and his death is known to the party giving notice, the notice must be given to a personal representative. If there be one, and if with reasonable diligence he can be found, if there be no personal representative, notice will be sent to the last residence or last place of business of the deceased. Okay, self-explanatory again. Section 99. Notice to partners. When the parties are to be notified are partners, notice to any one party or notice to the firm even if there has been a dissolution. So either one can be suffice as a notice. Section 100. Notice to person jointly liable. Notice the joint parties so are not parties must be given to each of them unless one of them has the authority to receive such notice for the other. Okay. Section 101. Notice to bankrupt. Where a party has been adjudged a bankrupt or insolvent or has made assignment for the benefits of creditors, notice be given either to the party himself or to his trustee or assignee. Section 102. Time within which notice must be given. Notice must be given as soon as the instrument is dishonored and unless a delay is excused as there provided must be given within the time fixed by this Act. Section 103. Where parties resides on the same place. Where the persons giving and the persons who receive notice reside in the same place, notice must be given within the following times. A. Given at the time, at the place of the persons who receive notice, it must be given before the close of business hours on the following day. B. If given at his residence, it must be given before the usual hours of rest day following. C. If sent by mail, it must be deposited in the post office in time to reach him in usual course of the day following. Section 104. Where parties reside in different place. Where the persons giving and the persons who receive notice reside in different place, the notice will be given the following times. Sent by mail, it must be deposited in the post office in time to go by mail the day following the day of dishonor, or if there is no mail at a convenient hour on that day, by the next mail thereafter. B. If given otherwise than run through the post office and within the time that notice would have been received in due course or mail, or if it had been deposited in the post office within the time specified in the last subdivision. Section 105. When sender deemed to have given due notice. Where the notice of dishonor is duly addressed and deposited in the post office, the sender seemed to have given due notice, notwithstanding any miscarriage in the mails. Section 106. Deposit in post office what constitutes notice deemed to have been deposited in the post office when deposited in any branch office or any letter box under the control of the branch office department. Section 107. Notice of subsequent party or time of. Where a party received notice of dishonor, he has the after such notice same time for giving the notice to antecedent parties that the holder has after the dishonor. Section 108. Where notice must be sent. Where a party has added an address to his signature, notice of dishonor must be sent to that address. But if he has not given such address, then the dishonor must be sent as follows. A. Either to the post office and to the place of residence, where is a custom for his letters. If he lives in one place and his place of business in another, notice is sent to either place. If he is sojourning in another place, notice will be sent to the place where he is so sojourning. But where the notice is actually received by the party within the time specified, it will be sufficient though not sent in accordance with the requirement of this section. Okay. Section 109. Waiver of notice. Notice of dishonor will be waived either before the time of giving notices or after the omission to give due notice in any way or express or implied. Section 110. Whom affected by waiver. Where the waiver is embodied in the instrument itself, it is binding upon all parties, wherewith it is written above the signature notice, it binds him only. Yeah. If the waiver is written above the signature notice, it binds him only specifically. Section 111. Waiver of protest. A waiver of protest where in case of a foreign bill of exchange or other negotiable instrument is deemed to be a waiver, not only of a formal protest but also of the presentment and notice of the owner. Section 112. When notice is dispensed with. Notice of dishonor is dispensed with when, after the exercise of reasonable diligence, it cannot be given to or does not reach the parties so to be charged. Section 113. Delay in giving notice, how excuse. Delay in giving notice is dishonor's excuse. When delay is caused by circumstances beyond the control of the holder and not imputable as default, misconduct, or negligence. When the cause of delay cease to operate, notice be given with reasonable diligence. Why is notice important? Why are we talking about notice? It's because you cannot file a case for collection unless the issuer, the drawer, was given notice that there was a dishonor of the promissory note or the bill of exchange they had issued. So notice is important. Section 114. When notice not need to be given to a drawer, notice is not required to be given to the drawer in the following cases: where the drawer is the same person, when the drawer is a fictitious person with capacity contract, when the drawer is a person to whom this is presented for payment, when the drawer has no right to expect or require that the drawer will honor the instrument, or C, where the drawer is countermanded payment. Section 115. When notice need not be given to endorser, notice of dishonor is not required to be given to an endorser in either of the following cases: where the drawer is a fictitious person again, or a person having capacity to contract, where the time is endorses instrument, where the endorser is the person to whom the instrument is presented for payment, and C, where the instrument was made or accepted to his accommodation. Section 116. Notice of non-payment, where acceptance refused. Where due notice of a dishonor by acceptance has been given, notice of subsequent dishonor by non-payment is not necessary unless in the meantime the instrument has been accepted. Section 117. Effect of omission to give notice of non-acceptance. An omission to give notice of dishonor by non-acceptance does not prejudice the rights of a holder in due course subsequent to the omission. Section 118. When protest need not be made, when must be made. When a ghost bin is honored, it will be protested for non-acceptance or non-payment as the case may be, but notice is not required except in the case of foreign bill of exchange. So that's it. We're already done with chapter 7.